I actually enjoyed this paper very much, and I was, like Mike Ramsey, pretty much persuaded by the basic thesis. That I didn't know to what extent that might be because this is the sole source of my information.
You don't need to read anything else.
But I was, nonetheless, you know that one common objection, I guess, or common argument, I take it in favor of, let's call it the revisionist interpretation, is one that you talk about a little, and I wondered whether it was a little more difficult than you gave it credit for. So I'm not really sure, but it seems to me like it might be. So you say the argument is that the framers and enactors of the 14th Amendment couldn't have been thinking about the problem of illegal aliens because there weren't any and the category didn't even exist. And it seemed to me, well, potentially that, I'm not really sure, Larry Sloan, that shouldn't matter, or some other views that shouldn't matter. But on the other hand, you might think, well, it does seem to bear on the sort of fairness and other concerns that people today have. And one might think it would matter to enactors, you know, it's something that might matter. You know, should someone who is here temporarily and illegally get some kind of preference over others who, you know, are trying to comply with the law? So it might matter to individuals. And you, in answering it, I think you say, well, on that we can go by analogy, that gypsies, I think you say, would have been the closest thing that existed at that time to illegal aliens, and they were clear, some of them, I gather, of the enactors were clear that they thought gypsies actually still, the children of gypsies would still be citizens and so forth. So, but of course, if gypsies aren't here illegally, then the fact that there's sort of an analogy here might not seem to speak very directly to this question, this concern, if it is a concern. So I just wondered if you could say a little more about that.
Yeah, I mean, I think that that's part of the reason why I'm reluctant to claim that I've, you know, proved anything. What I would say are the following things: that it is incorrect to think that the framers were not dealing with a situation in which there was a huge flood of immigration that was transforming society. So to the extent that our current anxiety stems from the fact that suddenly all the signs are in Korean or whatever, you know, that society, that an enormous number of people are coming into the country and what's happening, that was very similar, so strikingly similar to what people felt in the 1850s and 1860s. And so we can't assume that they did not foresee a situation of demographic turmoil. Okay, that's step one. Step two is we know that they did deal with at least one case of people who could not become citizens, and that is Chinese who came into the United States. And we don't want Chinese as citizens. That was the policy. And you know, in Justice Harlan's dissent in Plessy says there is a race that we will not even allow to be citizens, blah blah blah. And yet even the children of those immigrants would be citizens. And then you have gypsies. Now, you know, what does gypsies prove? I don't know, because there weren't very many. And I've spent hours trying to get figures. I mean, you can't look up census figures for gypsies. Some people say there were none, or there were people pretending to be gypsies, or nobody really knows. But what is true is that gypsies were a kind of construct, a kind of talking point that were alluded to by everyone who opposed the amendment as the reason why we should not have birthright citizenship. From Andrew Johnson on down, I guess you know the equivalent of the Republican National Committee was getting the talking points out. Everybody said, well, these people want to make gypsies citizens. And I think the fact that the framers were willing to say, yeah, we'll even do that, counts as some evidence, right? I certainly don't claim that if they'd been told there will be illegal aliens and there will be this many and blah, 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 that they would say, oh, of course. That's why I'm reluctant to claim that I've proved it. But I do think it's suggestive. And I do think that the argument that they did not foresee this situation is at most part right. Does that make sense?
Is it most?
Partially correct. It is not all correct.
Okay, we have a significant queue already. Larry Alexander's first.
Hey, can I get on?
Oh, yeah, John. Have you been? How long have you been waving your virtual hand? Well, I think we'll get to you. So.
Okay.
Yeah. First, I think I may have read a paper by John Eastman on this subject at some point in the past, but essentially everything I know about this topic I have learned from you, and then from a few remarks from Mike Ramsey just delivered. But neither of you have, completely assuaged my doubts over this, and here's why. There are, so you've dealt with, in the paper, you've dealt with the Chinese, and the Chinese were aliens, not eligible for citizenship, but they were here on a sort of semi-permanent basis. I mean, they were not going anywhere. They were going to be here on a permanent basis. Gypsies, I assume, were people who were in residence in the territory of the U.S. They just moved around and didn't seem to be very loyal citizens on certain indicia of that. But there are two other groups that were clearly here, and so there were no immigration laws and such. There was no category of illegal alien at the time. But there were two other groups. Now, one would be the foreign diplomats, right? So so there's the idea that the foreign diplomats sort of carry their home country with them in a sense. But I take it Ambassador Legrand and Madame Legrand could be out outside the embassy and so forth, and Madame Legrand has a child, and I'm assuming that child was considered to be a citizen of France and not the United States. But there were also then a category what we'll call legal aliens. Even though there's no contrast class of illegal aliens for a moment, there were clearly there was Herr Schmidt and Frau Schmidt. They're here on business or vacation. They're not here permanently. They're going to go back sometime. But Frau Schmidt has a child while they are sojourning around the U.S. of A. Now, what was as I understand it, there was no question that the Schmidts were subject to German jurisdiction, including the child. Was anyone at the time have assumed that young Adolf would have been a citizen of the United States?
Well, I can only say that someone would have thought that, because I have the language on page 21 of the paper, a very interesting little dialogue between Senator Wade and Pitt Fessenden. And Fessenden, who was originally supposed to be the sponsor of the 14th Amendment, but he was ill. And he came and he lounged around the language in the background and whispered. And Wade introduces the first citizenship language that will become the Citizenship Clause, and he's talking on, and then Fessenden is obviously whispering in his ear, and he says, "The Senator for Maine suggests to me in an undertone, persons may be born in the United States and yet not be citizens. Most assuredly they would be citizens unless they went to another country." And Fessenden says, "Suppose a person is born here of parents from abroad temporarily in this country." And basically the answer is, that kid would be a citizen too, unless he was the child of a diplomat. That's how I read that exchange. So that's the specifics. That's the only specifics I have on that, but it is reasonably specific.
Mike Ramsey has a brief intervention.
Larry was sort of looking at me while I was saying it. So just real quickly, this was part of the point of, or a large point of the Schooner Exchange versus McFadden quote that I read, is that prior to the 14th Amendment, there's absolutely no doubt, part of the Schooner Exchange, that people in the situation you're talking about, including the child, would be subject to the jurisdiction of the United States.
Well, sure.
They were also subject to the jurisdiction of Germany, of course, but they were subject to the jurisdiction of the United States. And since that's the same language that's then used in the amendment, that seems pretty strong to me that the answer to your question would be yes, the kid would be a citizen, absent some really strong evidence to the contrary. The diplomatic people, of course, are different, because the diplomats are not subject to the jurisdiction of the United States, pursuant to diplomatic immunity under international law. And so I think, at least for me, the text really drives this, is figuring out what that text means, and unless you can come up with a reading of the text that explains why these people are not subject to the jurisdiction of the United States, which I don't see where you're going to get it, that it just seems pretty conclusive. But I think you're right to think about the people, the traveling people, but I think that the traveling visitors are taken care of by the exchange.
Well, I mean, it's clear that they were subject to the jurisdiction. I mean, they had to abide by the laws, and they could be sued. And so the question is whether jurisdiction in that sense was what the sense was in
Move to Brian here.
I thought it's a really powerful paper, and I also found it quite persuasive, if not conclusive. On the first point, I guess, Garrett, you were thinking about how to respond to, quote, bad originalism, and that was part of your concern or motivation here. I would just say that this kind of article and many other kinds of articles, if anyone thinks there's bad originalism out there, the answer is to get in the game and write good originalism, and hopefully we'll all do that. And also, I think in terms of, there's always this risk of people's normative commitments or political commitments influencing what they do. The great thing about this conference is there are a lot of people around this table with strong conservative commitments, and now quite a few who might not have been here 10 or 20 years ago with fairly strong progressive political commitments. And surely we'll keep each other honest when there's a broader tent in that regard. Also, personally, I tend to think you might want to think about bracketing more the policy views and all that, as Mike was suggesting, but that's, it's your paper and how to write it. The second point on I think there might actually be a stronger analogy to the immigration situation, the 14th Amendment framers face. I can mean framers plus ratifiers, but to be simple, I'll just say framers. And the situation we face now, although legal immigration as it existed in the 1860s is obviously not the same as illegal immigration today, it's also absolutely not the same as legal immigration today. For example, there are many more similarities between illegal immigration today and legal immigration then. Both were uncontrolled. And I don't know the history well enough to know why there weren't comprehensive immigration laws at that time, because certainly there were attitudes in the country that were very hostile and negative to foreigners. There were people who wanted to control it. For whatever reason, there weren't laws on the books to control it, but there was a sense the country's being swamped in an uncontrolled, unconsented way by influxes of people, which is exactly the sentiment today. Legal immigration today is highly controlled and regulated. It's just there's obviously de facto uncontrolled immigration at the same time. So that would suggest you could actually push your point, I think, considerably further. Not just in terms of Chinese and Gypsies being somewhat analogous to illegal immigrants today, but that all immigration then is highly analogous to more illegal immigration then. The other point, and this is a terminology thing on page 3, I'm not sure whether this was your terminology or whether you were just kind of echoing what Schuck and Smith and others wrote, but it seems to equate birthright citizenship with citizenship by law of the soil. And unless I'm mistaken, birthright citizenship would include birthright citizenship by virtue of blood or parentage and citizenship by the soil.
But not 14th Amendment birthright citizenship.
Well,
that only refers to born in the United States.
Yeah, I know that. But I mean, you're saying, you say advocates of abolishing or modifying birthright citizenship, note this or that, but I think what you're talking about is advocates of abolishing or modifying use solely citizenship. Right. Yeah.
Yes.
And so birthright clearly is a category that has two components, birthright by blood or birthright by soil. And that leads into a further point, and as far as, I haven't read Schuck and Smith, but I was very puzzled and interested by this claim that use solely citizenship was contrary to consent, was medieval or something. How is that the very same objections would apply equally, if not more so, to birthright citizenship by parentage? The child doesn't consent to who his or her parents are any more than to where the child is born. And so it seems to me that's a scattershot critique of a law of the soil that doesn't have any traction that I can understand. And beyond that, and this gets beyond what your paper's about, because for me at least, I think you've, to a large extent, exhausted the issue. There's just this interesting philosophical debate. Should we have a constitution that's based on citizenship by soil or birthright? Which of those two conceptions, if either, is more consistent with what we might each take to be the best concepts of consent, individual autonomy, a just society, and all of that? And I can think of a lot of reasons why although there's no way any regime of law can be consistent with a child's consent, because children are helpless, beings, that I think there's a better philosophical argument consonant with consent to have law of the soil citizenship, in addition to the likely additional options of citizenship. Most countries typically would offer citizenship to any child of their own citizens wherever born. Final little point, and I don't know much about international law, but in what sense, other than diplomats, would you say that there's anything other than exclusive jurisdiction over foreigners? Like, I don't think Germany has any jurisdiction at all over Germans when they're in the U.S., but am I wrong about that?
You are wrong.
Okay, all right.
And
if you think of goes the other way, try going overseas and committing a crime that's punished, that's criminalized by the U.S. Code.
Oh, okay.
Well, the anti-torture statute makes it a crime to commit torture
or
overseas.
sex tourism, there's massive prosecutions going
I
on.
was thinking about Americans.
Or material support for terrorism.
Bribery of foreign corporations.
Okay, yeah.
And in the 19th century, there was still the phenomenon of extraterritoriality in a number of places, much more strongly than there is now.
I was more thinking that your home country couldn't help you necessarily, but that, I'll leave that aside. Thanks.
So I really enjoyed the paper, and I agree with it. I'm just reading from the actual opinion in Wellington Mark, and basically the government made an argument relying very much on international law. Right? So they said the word "subject to the jurisdiction thereof" needs to be construed according to ambient international law principles of jurisdiction. So, for example, we can concede that ambassadors are covered, but there were live issues in public international law about household servants and consuls who were considered quasi-diplomatic officials. And it's interesting because the government actually said, they quoted the Code of Napoleon of 1807 and said that the French law has changed from use solely to jus sanguinis, and in fact the international law rule had changed by 1868. And Gray's response to this is there's little ground for and this is his opinion, for the theory that at the time of the adoption of the 14th Amendment of the Constitution of the United States, there's any settled and definite rule of international law inconsistent with the ancient rule of citizenship by birth within the Dominion. So, I guess my question is, was there, it seems to me that subject to the jurisdiction thereof is necessarily incomplete. It has to default at some level to international law, at least with regards to the ambassadorial aspects of it. Was there any discussion of other jurisdictions? And when the AG in the case started pulling this out, was this a new concept that they'd introduced in 1898, or was the discussion?
I'm not sure which is the new concept.
The idea that the word "subject to the jurisdiction thereof" had to be construed in accordance with what international law rules were governing, of these issues, or was that stuff present in the debates? And is there, and if not, then is this something just an artifact that comes in the case later?
I'll tell you, frankly, that from my reading of the debates, there's very little. Ben Wade, talks about the legal fiction that diplomats live near the United States, and that's the only public international law colloquy I remember. There's much, 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 much more very, very, very practical discussion about jurisdiction over tribal Indians by Midwestern senators who had to deal with them. And one of the things that's in the paper now that isn't in the draft that you all got is a section that just outlines the situation of tribal Indians who were basically extraterritorial on U.S. soil at that point. If people broke out of the if Indians broke out of the reservation and came out of Indian country, which was a statutory term, and came and burned your house and stole your livestock, they couldn't be arrested, they couldn't be held by the state, nothing could happen at the state. Your only recourse was to go to the United States and say this happened. The United States would indemnify you, and then go to the tribal government and say, it was very tacky of you to burn this guy's house down, could you pay us back? So it was very complicated. It was governed by the Indian Trade and Intercourse Act of 1834. And it's very much like things you would be familiar with. What was the term in your denial of justice?
Denial of justice.
Yeah, it's very similar because the U.S. reserved the right to invade Indian country and get satisfaction. But that's the discussion that occupied most of the time. And it was, as I say, very practical, very much involved in people who had been lawyers in the Midwest saying, what's this going to do to politics in our states?
Lark.
Yeah, I just want to suggest that the frames of 1787 actually help you out, I think, in the case that you're making for a capacious reading of the citizenship clause, because of another context in the Constitution where they self-consciously protect the progeny of persons who lack rights under the jurisdiction, namely the provision for the consequences of treason. Right? The kids of loyalists are not so different in this respect, perhaps, from the kids of illegals. Right? No corruption of blood when you're attainting them for treason. Right? And the background law would have stripped the kids of all civil rights. Right?
That's terrific. I like that a lot. I'm stealing it.
Okay, good. Moving down. Fred, yes.
I have to confess that during Jack's presentation and Jim's presentation, I was thinking mostly about Garrett's paper, because I thought it illustrated two things that were bothering me about those other presentations. I'm very skeptical that it makes much sense to talk about original meaning outside of original expected applications. And I think actually Garrett's paper shows that very well, that the entire discussion about the meaning of the citizenship clause, again and again, seemed to be in terms of the applications that they expected. And so when you try and abstract a principle out of that, I'm not saying that's not a legitimate interpretive move, but it strikes me that it's not an originalist one. It permits us to read back into text a meaning that the authors of the text didn't intend, and that those who dealt with the text at the time didn't understand. And I guess that brings me to the second point, which is, I guess, what one could call the dark side of the distinction between meaning and original expected application. Like everyone else, I don't write in this area, I don't read in this area. Everything I know is what you've told me. So I was actually pretty surprised that it wasn't just Lou Dobbs, but Roger Smith and John Eastman. These are not psychopaths. These are respected academics. Unlike Lou Dobbs. So you read the citizenship clause, and it has a pretty rule-like quality. If you're born in the United States, you're subject to its jurisdiction, you're a citizen. And so it strikes me that the original expected application move permits every rule to be a standard waiting to happen. As long as there's enough political pressure to create ambiguity, then all of a sudden, maybe it's really about exclusive jurisdiction and about commitment and allegiance and things like that. And normatively, I like Jack's and Jim's works because I consider myself a progressive. But I have to say that original expected application, those sorts of things, sort of opens the door for what I would call regressive interpretations, or maybe, since we're not name calling, just conservative or narrower interpretations.
I agree with that, and I think that's why I made my clumsy attempt to talk about the burden of proof. I was not trying to say, I know what they would have thought today. I was trying to say that the people who say, and this is a direct quote, that their clear intent was something else, had better be able to show that clarity, and they can't. My epistemology and my philosophy in general comes from Karl Popper. And Neil Richards, the historian at WashU, once said, truth in history is ephemeral, falsity is not. And so I was trying to falsify an interpretation that I think is wrong, not to say mine is right in every regard. I may not have done that as skillfully as I would like, but I will take your remarks and do it better.
Okay, down to Randy Barnett.
Sorry, Jim left because part of my comment was sort of aimed at Jim.
Coincidence?
But-
I'm going to get in the next session.
Let me just start with what Fred said here. This goes to what I'm about what the advantages or disadvantages of originalism are. Okay, there's a political controversy that comes up, and it has to do with illegal. Illegal immigrants. I'm not sure what work this does but I know what this. I'm from Georgetown. I know what this work does. So
I figure quote marks being John being put in here.
So anyway, so we now a new political controversy, and the evil Lou Dobbs says this, and then the benighted John Eastman rides to the rescue of the evil Lou Dobbs and comes up with a plausible. It's exclusive jurisdiction. That's what it is. And there's no exclusive jurisdiction here. There are aliens. I mean, look, Medellin was supposed to get consular rights before you could prosecute him as a murderer. So, that seems like a good idea in that context. Why not in this? So, therefore, there you have it. Constitutional. We don't have to give citizenship to babies. So, that's it. Well, I don't know. Garrett comes back and he says, "Well, wait a second. Is that right? Not right as a matter of normative." Standpoint of whether this is the best moral reading of Section 1. Is the best moral reading of Section 1 that illegal immigrant babies get to be citizens, or is it the best moral reading of Section 1 that it's not? No, it's not that.
Depends on whose morality.
Exactly. Well, a lot of other things. But Garrett says, no, wait a second, that's wrong. Wrong from what point of view? Wrong from the point of view of the original meaning of this language. Oh, really? What do you mean? Well, let me just show you. Let me just tell you a story. And, I just wrote this book about the 14th Amendment, and there's this other stuff. And guess what? John Eastman is wrong about John Eastman and the originalists, also John Harrison in quotation marks. I'm not exactly sure what the quotation marks do. I know what they do with illegal, but I don't know what they're doing with originalists throughout the paper. I would actually recommend you take out the quotation marks, or give John Eastman.
You should put in comments.
And the other folks a different name than originalist, because this actually would alienate an originalist to see this going on. But anyway, it turns out you make a very strong case that you're right and they're wrong. But about what? What's the thing about which you're disagreeing? You're disagreeing about the original meaning of subject to the jurisdiction thereof. And you make a very powerful argument. Now, the point here is that with respect to a constitutional argument, there's a there. The there is the public meaning. I believe it is the public meaning, but you could talk about intent if you wish to. But the public meaning of this clause in context. And then you get to, guess what? Under this form of discourse, you get to appeal to evidence to support your claim about the empirical linguistic fact concerning the meaning of subject to the jurisdiction of. John now is free to come back after reading your work, read your sources, provide other sources that those of us in this room are not aware of, and suggest that there's something that you've missed that's important, and we, the neutral reader, reading this debate, will ultimately reach a decision as to who has the stronger argument, not necessarily who's true in some absolute sense of truth, but who has the strongest argument about the likely meaning of this term in context. To me, that's a big advantage, and it helps us resolve this highly contested political question about which we otherwise just could fight each other off and start making all kinds of arguments about what should happen to illegal babies or not. But we're not doing that. We're going to resolve this matter peacefully by reference to something called a constitution, a written constitution, which has already been laid down before the illegal immigrant problem arose of the kind issue arose of the kind we have. It's a pre-existing rule set down to decide this question. Now, is this an intended application of that provision? Probably not, although that's a beautiful little illustration of how they imagined this possibility, but they might not have imagined millions of them. But that doesn't matter, whether it's an expected application. What matters is the meaning of the words they picked, and that settles the question now. If we don't like that, the burden is on people who believe in the Constitution to amend it and change that, and I'm sure there's some people who would like to do that. So that's all. I think this also just illustrates an advantage of originalism over just fighting it out about the best moral reading of what this text means. And then I would also then say, but if that's true, Garrett, again, this goes to what the meaning of the quotation marks were around originalists. My question to you then is, if you're right and you win because you're right, are you willing to lose on another matter that you feel strongly about because the original public meaning of another provision of the text on balance, after weighing all the evidence, goes against you? Because it seems to me that that's kind of the bargain one makes when one submits oneself to the written Constitution. So that if it's on your side today, that's super. But that means if it's not on your side, then you're willing to go along with the other way until the Constitution is changed. And if that's so, then it seems to me then you're an originalist.
Well, I don't want to belong to any club that would have me as a member, but I appreciate the offer. I will, but I mean, I think what you say is extremely persuasive and interesting. There is an initial step that I probably didn't make clear, which is I regard this as a case where if someone really wasn't an originalist at all, the person could say, sorry, I'm a textualist. Born in the United States? Check. Jurisdiction? Check. Citizen? Check. And then along comes Mies and Eastman and says, no, we have all this evidence about original intent. Our textualist, which is not me, because I have a soft spot for originals, but our textualist says, sorry, you don't carry your burden of proof. Right? In other words, the text is clear, that's it. I think that's a perfectly valid approach as well. It doesn't get to my subjective morality. As for the second question, I have to say that it seems to me that if the Second Amendment really does contain within it an individual right to bear arms, then the case for incorporation and application of that is pretty darn strong, and that's a result that I find appalling. So I think I clear the integrity bar there.
You find it appalling, but we don't know whether you're willing to accept it.
What am I going to do, right? Give me that gun. I'm going to accept it. I used to teach in Oregon where the law was you couldn't keep concealed weapons out of the classroom, so they never would discuss the Second Amendment. They would continue with that. But that's my point. I think there are a lot of cases where it's not clear. And I don't want to be suggesting by my method that I think we can answer all or even a huge number of these questions by this method. I think some of them we can, and I think this is one.
Okay, the next person on the list is my grad reporter, John Muir, after mine.
Well, I guess I'm on the list, although what I want to do is speak for John McGinnis, who was originally supposed to comment on this paper. And so first, John wanted to say how sorry he was that he couldn't make it. And he thought that, I could at least convey this one comment that was sort of crystallized from his thoughts about Garrett's paper. And I guess the first point was that he found as an originalist, he found the argument quite persuasive. Not necessarily agreeing with it morally, but as Randy suggests, but finding it very powerful as a textual and historical discussion. So that's first. And then he thought he wanted me to add this other point about he thought this had some implications perhaps for the view of the Constitution as getting meaning from social movements. And John said, well, there's some fair bit of popularity for the idea that illegal aliens in the United States their children should not become citizens. And, so can we imagine a social movement of this sort arising and then having enough influence to get the courts to construe the 14th Amendment to deny that, to do what Judge Posner wants to do. And John thought that, well, there's a real problem here with this happening. And the problem is actually the very powerful textual and historical case that Garrett makes, suggesting that this is not just all about social movements, This is also about traditional legal materials, if you will. And this is an interesting example of that.
Okay, John, you're next.
Thanks. Well, I'm not going to make any quotation mark gestures. I do want to partly connect this to Curt Lash's paper by asking in how technical a sense the concept of subject to the jurisdiction thereof is being used in the 14th Amendment. Because the principal examples involving Indians and diplomatic personnel lead me to ask, suppose Congress now were to pass a statute saying no court in the United States, state or federal, shall exercise personal jurisdiction in any civil or criminal case over, and here insert a legal definition that would mean child of illegal aliens. Maybe I should have the scare quotes there. Child of illegal aliens who is younger than 2 years old. Could Congress, by disclaiming at least that kind of jurisdiction, which it probably doesn't really want, I mean, how often are you going to prosecute a 2-year-old, take children like that outside of the 14th Amendment? Because if jurisdiction is being used in sort of the jurisdiction of the court sense, as the examples of Indians and diplomats suggest it is, maybe Congress can do that.
Never thought of that. Let me think about it.
What's the claim now?
We pass a statute that says no American court has any jurisdiction over the child of illegal aliens.
Right, or more broadly, how far can Congress go toward, this is the question, sort of what is jurisdiction? Can Congress really get rid of jurisdiction?
Could Congress oust state courts from that jurisdiction? Does Congress have that power?
Well, I think not clear, although I think most people today would say yes as part of its general foreign affairs power, since it's dealing with people, or its immigration powers, since it's dealing with illegal immigrants and it's dealing with people who are the children of foreign nationals. For some purposes it can.
I'm not sure what's special about this case. That's the only thing that's puzzling about the question.
I don't know how well you can hear. Jack Balkan asked, what's the difference between this and any other jurisdiction stripping?
Yeah, like, you strip jurisdiction for school prayer. Well, you can have school prayer. You strip jurisdiction for busing. Well, you can't have busing. This sounds like an ordinary jurisdiction stripping case. What's special about this case?
Well, no, the question is whether it is the subjection of the people to the jurisdiction of the courts as parties that creates, that brings them within the citizenship clause. I don't mean taking over jurisdiction over litigation over whether they're citizens. I mean making it impossible to sue them.
Let me propose something to think about in this regard. And that is that the two classes that are mentioned in the legislative debates, as I read them, that is tribal Indians and foreign diplomats, were protected from the jurisdiction not by congressional grace. In other words, not by Congress saying, well, we don't think we'll do this, but by treaty. This was the treaty era. The treaty era didn't end until, I believe, 1871. And so our dealings with tribal Indians were entirely by treaty that would govern this question of jurisdiction. And the same was true of our dealings with diplomats. That is, the exercise of jurisdiction was restrained by customary international law and treaties with the sending countries. So that it is different from Congress just saying tomorrow, oh yeah, we had that jurisdiction, but we don't want to use it anymore. Because there's nothing compelling Congress not to have the jurisdiction. I don't know whether that's a dispositive answer or not, but I do think it's significant.
So if the United States entered into such a treaty with the country the parents are from?
Extraterritorial? Boy, I don't know. Do it and then get back to me.
Meanwhile, while we ponder that.
But I don't understand what the question is. Does this mean that after the jurisdiction stripping statute is passed, that if a person born in the United States of alien parents commits murder, that they're not subject to judicial process? Is that the claim?
Only until they're 2 years old.
It's the Chucky statute.
I have the next question. And I have two what I hope are helpful suggestions. And I just want to echo my agreement with the general sentiment that this paper was extraordinarily persuasive, and for people who are originalists, it's extraordinarily persuasive on originalist grounds. But here are my two suggestions. One has to do with the meaning of jurisdiction. And it might be helpful to follow up on the spirit of John Harrison's suggestion, which is a investigation of what was meant by jurisdiction at the time. And I think what you will find is that there was what we now call personal jurisdiction and jurisdiction to legislate that governed all persons within the territory, right? And a classic citation for that proposition would be Pennoyer versus Neff, which is a little bit later, but at least is purporting to express the understanding as it had existed for quite some time in the United States. And so that's the first suggestion, is that there might be more resources to draw on in determining what was meant, in what sense the word jurisdiction was meant. And then the second suggestion is that there's a little bit of intratextualism here that you are not fully pursuing, and that is the relationship between the citizenship clause in the 14th Amendment and the natural-born citizen qualification for being for eligibility for the presidency. And if you pursue that line back, I think that you will discover that the phrase natural-born citizen appears to have been coined for the Constitution, but appears to have been related to a pre-existing legal concept in both American and English law and in English political theory, natural-born subject, and that the concept of a natural-born subject is very closely related to this idea that persons born in the territory are, we call them citizens, the English would have called them subjects. And it might be particularly useful to look at the exceptions to that existed in English law. So one of those was the children of foreign ambassadors and other representatives of foreigners who were considered to be subject to the foreign sovereign. And another was if you happen to have the unusual situation of the children of a monarch being born outside the monarch's own territory, right? They were subject to the jurisdiction of the monarch, right? Even if the King of England was in France when the child, or the mother, the Queen of England was in France when the child was born. And then there's another exception, though, that I think might potentially be relevant and could give rise to a worry, right? Which I don't think that this is a defeating objection, it's just a worry. And that is that under the English doctrine of natural-born subjects, the children of foreign soldiers engaged in hostilities against the King of England would not be considered natural-born subjects. And then this could lead to questions about some possible groups of illegal aliens. They may be far-fetched scenarios, but for example, if you have a bandit party that crosses the border, and then one member of the bandit party gives birth to a child on the raid, right? There'd be a question as to whether or not that bandit party that comes from outside the jurisdiction of the United States would be within the jurisdiction for the purposes of the natural-born subject clause, and then for this purpose as well, given that they're sort of engaged in hostile action. And then just the final point I would make is that the political theory behind the natural-born subject concept in English law did have to do with allegiance, right? But their concept of allegiance was not Lockean or voluntaristic. It was that you owed allegiance to the King of England merely by fact of being born in England, right? So it seems to me all of that sort of provides an additional bit of intratextual detail that might be illuminating in trying to come up with an account of what they would have meant by jurisdiction.
Well, the natural-born citizen language, as Randy knows, was very important to the people like Tiffany and Spain. Whether to the extent it goes back to English law, is more speculative from my point of view because I just don't know. But that's how they proved that, to their satisfaction, that slaves and the children of slaves were citizens, because the Constitution says natural-born citizen. It doesn't say, and Bates uses this in his opinion, it doesn't say white, natural-born white citizen, therefore everyone naturally born in the United States is a citizen. So that part of it is correct.
We actually started about 5 minutes late, so if we could just hear it quickly from Michael Curtis, and Jack Balkin, who are on the queue.
Yeah, I guess I have a couple of comments and questions. One is, as I look at Garrett's paper, it seems to me more than one method of interpretation is at work, maybe partly in reputation. So it looks to me like there's a textual method. Just read this text, what does this text mean to us? Then there's sort of an original meaning of the text. Then there is intent. What do these people understand it to mean? You could say that's original meaning, or you could say this is an indication of intent. There's, I don't know if you want to call it ethical aspirations or structure, but the idea that there was this pervasive spirit behind the 14th Amendment that we didn't want to have a subordinate class. Now, for me, the fact that all of these things point in the same direction is more persuasive than I know this is heresy here, but it's more persuasive than a single, a single thing. Then I wanted two other things. You can always pass. You're a faithful person if you accept one obnoxious thing. I accept the one obnoxious thing that Justice Scalia has proved, and the history proves that under the 14th Amendment, I know that wasn't what he was supposedly proving, that the right to bear arms is an individual right. I don't like it. I accept it. He's proved it. On the other hand, if originalism means that we are stuck with the understanding of the framers of the 14th Amendment as to the role and equality of women, and we're stuck with their understanding as to whether or not segregation is permissible, then quite frankly, I am not, if that's what being faithful requires, I am off the boat. And also I think...
When did you get on the boat, Michael?
Okay, I've never, well, it's why I've never been on the boat. I've never been on the boat. If that's what it means, then I think it would be awful to accept original meaning. Because what you'd be saying is, all these people who didn't get to say anything about the Constitution and even the 14th Amendment are a subordinate class, a sort of an inferior caste, and if they didn't understand it was an inferior caste, well, they're what? And so the people in the country have to believe that the Constitution is a good thing, and that it really does secure liberty and justice for all, and that sort of thing. So if you have a system that builds into it these disgusting and obnoxious things by current understanding, then you're doing a great disservice to the Constitution. You're not being faithful to anything good that's going to come of it. Finally, why do you have to have lots of burden of proof? Why isn't just the preponderance of the proof enough? Maybe it's the presumption of constitutionality of statutes would explain it. But I want to, this will be a question for you, Garen. I really do have a question now. Suppose, I think you and I agree. Yeah, you and I agree that the framers of the 14th Amendment should be read as applying the liberties and the Bill of Rights to the states. and that the better evidence supports that. But the world is full of people who say, well, there's evidence, but it's not enough. And so if you have the lots of proof question, and you have all these people who say it's not lots of proof, then do you have a problem? But if a court has to give some meaning to it, right, can they say, oh, gee, well, they're going to give meaning to it one way or the other. There's not lots of proof. There's significant proof, but it's not a lot. So
I'm afraid that's going to have to be a rhetorical question.
Okay.
Apologies to those who are still in the queue. Thank all of you for stimulating discussion.